So we know what we're here for. Going to court for a debt, legal processes and client options, and it's fortuitously the 29th of February 2016. Outline of the session. First thing, so we're going to be talking about first things first. What needs to happen at the very, very beginning when we're talking about the court process and the debt recovery process. The flow chart that I'm going to be talking about is the one that is basically in the little handbook. I think it's page 4 of your handbook. I'm not going to go into that detail. You've got that in front of you. You've got that as a resource when you're actually dealing with clients. What we're going to be doing is value adding to this. Thank you very much for the term value add. It's brilliant. And so what we'll be talking about is, in a little bit more detail, pre-claim and pre-judgment options, and that coincides with sections 1 and 2 of the booklet. Post-judgment options, section 3. Enforcement, so basically investigation, examination, summons and warrants of sale. And then I'll just briefly talk about other enforcement options or actions at the end. Some basics. Now I know some of you financial counsellors have been around for a long time and you'll know all of this. Some may not. So the difference between civil and criminal. Criminal is basically the state versus a person, and it might be the things that we just think of normally as crimes, things like theft, murder, whatever, versus civil action. We're talking about civil action today. So civil action doesn't involve the police, doesn't involve the state. It is a dispute between two individuals, between me and Carolyn and I, whichever way around it is. What we're talking about, so it doesn't, even though at the end of the process, sometimes if somebody refuses to pay, they can actually be put into jail, which is a very strange thing. The whole process we're talking about today doesn't involve the police, doesn't involve the state in any way. The creditor has the right to take legal action. So there's very little that you can do to stop a creditor from taking legal action unless there's some sort of signed separate agreement that won't happen. So that's a right the creditor has. And a lot of people say, well, you've got to be able to stop that from happening. Well, you can't stop it. Just bear that in mind as you're going through. Also, costs are added at each step of the way. And each step of the way, you would be aware, legal costs get added, and that, again, is the right of the creditor to ask the court to add $50 for the attendance of a solicitor, $52.50 for the issuing of a warrant. I think that's the amount. So you can see how at each step of the way, a little bit more gets added on, as well as interest. The concept of default is something else that we just need to have in the back of our mind. Default means basically when you don't take a step in, and we're talking about in the court action, not taking a step has a consequence. So not filing a defence, not turning up to court, not responding to a warrant, that's all about default. That's why we use the word default there, and you'll know it from your default notices. And we'll use the booklet, Going to Court for a Debt, as the basis of our presentation today. One of the things that I find when people ring me is that there are certain bits of information that they haven't got that doesn't help me to help the financial counsellor that's called. So gathering information to me is absolutely critical, and there are various sources of information, one of which we'll talk about a lot in our workshop, in our role plays a little bit later. So default notices, letters of demand, contract documents, court documents, all of those are going to give you part of your picture. And learning how to find the detail in those is a bit of an art. And I still get tripped up. I still think, oh, how old is this document? And then you look at it and realise that it's 2014 and we're now in 2016. The other thing that's important are the players or the parties. We refer to them as parties, but they are the people on either side. So usually you know who your player is. Your player is your client, but the parties, the other players in the whole scenario are also, so we need to know who is who. Pretty important when we've got something like a joint debt, so joint and several liability where the girlfriend and boyfriend have signed up for a joint loan, buy the car, boyfriend's nicked off with the car and she's left with the debt. That's a classic. Husband and wife have split up. Also something you probably come across quite frequently in your day-to-day practice. Insurance debts, and so insurance claims where the insurer is chasing your client and your client's not insured themselves. Who's who? Who's playing in that? And we'll talk about insurance in a little bit more detail in a minute. Where a debt has been assigned or there is an agent appointed for collection. So do we know the difference between the two? Do we know that the assigned debt is a bought debt? So all of the rights and liabilities all get bundled up and get assigned to, who we've got, Lion Finance is a classic. So that's also important to know who is actually chasing this debt. And is it why do I owe Lion Finance money when I've never actually engaged with them? That's because you actually got a credit card with, let's say, National Australia Bank or GE Finance or whoever. And just going into that insurance debt, the claims by the insurer in the name of the insured, and that will become very clear when we start talking, when we look at some of the bits of paper. You know, how many of you have seen these letters from insurers saying there was a crash, your client's responsible, and pay up. One of the other things, so we're talking about the players, we're talking about kind of the substance of the debt, we're talking critical dates. Ask your client, when did you get this? Oh, I don't know, 3 weeks ago. Was it 3 weeks ago? Was it 3 months ago that you got this piece of paper? Does anyone actually ask the creditor when they sent that letter of demand, when they sent that notice of default? Does anyone actually ask? Or, yeah? Do you ask them? Do you believe them? Because, of course, one of the critical things is the date of service of something. So it's not the date that they sent it, but it's the date that they served it. It's the date that it was actually landed in your client's hands. For court documents, asking the court is probably going to be your best bet. A creditor might say, well, we served the statement of claim on your client on the 1st of February, but the court actually has a record of when the document was served, and that might be the 6th of February or the 7th of February. So very big difference between the 1st of February, which is the date they've taken the document into court, stamped it, and it's been filed, the action's been commenced. Big difference between that and the 7th of February. So asking the court is actually a really, really good option, and probably would be the go-to, I would say. Do searches on your client's name, which is kind of why it's important to know who's who. Because there might be, your client might be Smith, and you're going, well, there are lots of Smiths, who's on the other side? So knowing who, is it Lion Finance, is it Joe Bloggs who's actually suing as the insured person, but the insurer is doing the work to chase the debt. It's a complicated thing called the right of subrogation. The insurer steps into the shoes of the insured person. So why hasn't the client paid? Who asks that question? Does anyone ask that question why haven't you paid this debt? Yeah, okay, so it's fairly essential that we find out. And whether or not, then do you make the assessment about whether or not they need some legal help with a claim. We will talk about that, some of the cues to listen for, as to whether or not they actually do need some legal assistance to move on, to deal with a claim. And have they made a part payment? Have they started to actually try and deal with this debt? There's something else that I thought I'd throw in as a curveball here. The last contact with the creditor? Why do you think this is important? Acknowledgement of the debt, but why? Why is that important from a legal perspective? The limitations, yeah. So does everyone understand about debts that basically run out? 6 years?
So dealing with debt and debt recovery and a debt issue that's gone to court, as far as the financial counselling role is concerned, is really no different than you would deal with a debt in any kind of circumstance, in the sense of just doing your job as normal. You know, we do the income and expenditure, we put the debt wherever it's at in the process of debt recovery, be it pre-court action or during, or whether it's got to court, we put that in the context of the overall financial position, and we look at the options and so on as normal. And of course we will look at some of the legal liability issues, but I'll let Julia expand on that. I would say though that in terms of legal liability, that obviously we're limited in what we can do in terms of, so the role might be identifying a legal liability issue, but then we're limited in what we can do about it, and so obviously we need to keep in mind that our boundaries, our parameters, and that we might need to refer, and obviously Julia for us in South Australia is a really good referral source. I would also like to say, most importantly, that just because a debt has got to court doesn't mean to say you look at different overall options for your client and their debt, or perhaps to put it another way, that bit about putting that debt into context. And my example for that is if, for instance, a good option for your client is something like bankruptcy, then that debt, whether or not it's got to court, they can still put into the bankruptcy, so you wouldn't be dealing with that separately. So I think I'll leave that.
And here's my little joke for the day. Who are you going to call? All right, so some technical legal stuff, which is a legal term. In the Magistrates Court, there are two divisions. There's the minor civil division, where debts are under $25,000. They used to be under $6,000, and then in 2013 the state government thought, wow, this is a great idea, we'll increase it to $25,000 and we'll keep lawyers out of the jurisdiction. That's good for your clients because it means that legal costs get kept down, but it can also drag things out if there is actually a problem. So good and bad in there. A general claim is up to $100,000 now, and that includes personal injuries claims. So bear that in mind. It's probably, you might come across people with credit card debts or a shortfall from a mortgage, for example, and that's likely to be sort of $40,000 or $50,000 or maybe even more. If it's above $100,000, it goes over into the district court, which is the big building on the other side of Victoria Square. I mean, the basic processes for debt recovery in both jurisdictions are the same. There's the similar steps, and in fact there's similar steps in every jurisdiction. There's no real mystery. But I guess the thing to bear in mind that costs are actually on a higher scale in the general division. Secured and unsecured debt, everybody probably does know the difference, but let's just go through it and make sure that we're clear. So for example, a secured lender can seize the goods to sell without going to court. So a car, a boat, a house, you're doing house repossession this afternoon, as I understand. But if there's a shortfall, then that aspect of it's going to be unsecured debt. And most of the things like a personal loan, a credit card, a loan between friends, unsecured. basically unsecured debt. So you can't, so the lender doesn't have anything to take to sell to recover the debt. The security being the thing like the property, like the car or the boat. That's the security for the debt, but the unsecured part of it is basically what we're talking about here. All right. In a magistrate's court, a creditor is required to give notice of proposed court action, and in South Australia it's 21 days. I've noticed that in interstate jurisdictions, a lot of the debt recovery letters will come from interstate debt recovery agents, and they'll say, we're going to sue you in we'll take court action in 7 days, we'll take court action in 2 days, we'll be suing you, you've got to pay or else. Our court rules provide for a 21-day period, and there's a notice called the Form 1A, and you may see it. It's not used often by debt recovery agents because they don't know about it. They don't care about our rules. What they want to do is they want to give plenty of notice, and they'll continue to harass your client. They'll probably send several debt recovery letters first before they actually issue proceedings. Strictly speaking, if the 21-day notice period is not given, they can't recover their filing fee. And a lot of people don't pick that up. But I would be, if you're in that situation, give me a call and let me have a look at, because there could be an argument that those letters, one that says 7 days, one that says 14 days, one that says 21 days, suddenly you add that all up together and the person has had plenty of notice, and there's a good argument that they have met that requirement for the 21 days. And of course, as you know, under the National Credit Code, so the NCC, 30 days is the required length of time. Now, Carolyn asked me this little point about National Credit Code proceedings must be commenced where the debtor lives. There is a requirement in it might be the regulations, it might be buried somewhere in the law, that if a person has a credit card debt or an unsecured loan and the company is based in Victoria or New South Wales, they can't issue proceedings there. They must issue proceedings here in South Australia, so in the Adelaide or the equivalent magistrates court. So just bear that in mind. If you get something that, I occasionally see it in the court list where it's an interstate judgment. Interstate judgments can actually be registered here in South Australia and enforced here in South Australia, but it's usually a debt arising out of some other cause of action, not a National Credit Code debt. So be aware of that. Now, a lot of your clients will come to you and they've got so many other things going on in their lives, and they've got probably masses of debts racking up left, right and centre. Something I hear quite a bit in the debt court from the creditor's agent is that you may have seen the I&E that I don't know, has everybody seen that awful thing that the court prepares that sort of people scratch their information in? And that's what they get questioned on in the debt court. But the point that I'm trying to make is that often people will negotiate pre-claim with a creditor. I'm going to pay $50 a fortnight towards this debt. And to stop court action, thinking that that's what the right thing to do is. The creditor's agent will then say to them in court, well, hang on a minute, my client has got a judgment debt. My client's debt takes priority, which I don't think is actually quite right, but in any event, judgment debt. So there's often questioning about why did you enter into a payment arrangement when you could have dealt with my debt as the judgment debt takes priority over other informal arrangements that have been made. So there is that option to negotiate the payment arrangement, getting advice about legal options and the right to question the debt, and also, as Carolyn mentioned, going through other options for the client to deal with what may well be quite unmanageable debt situation. All right, so with pre-claim and pre-judgment options, what we're going to talk about now is different types of claims requiring different approaches. I've decided rather than to go through the booklet, which you can do, is to pick out some aspects of debt recovery and have a look at some suggestions, and you may well be able to give share with the rest of the group your ideas as well and some of the things that you've come across. But certainly different types of claims actually do require different approaches and things to be aware of. Don't assume that whoever you're dealing with is right. Even if they're a lawyer, don't assume that they're right. Not me, but because sometimes they get it wrong, and clearly it's in their interest to push and make sure your client pays full tote odds on something that might well have a defence. Early negotiation might avoid additional costs, but we've seen that it's maybe to your client's advantage to allow the person to allow legal action to be taken and judgment to be entered, because for a start it fixes all those runaway costs and fixes interest as well. So court interest has gone through the roof, down up to 10% now, but then you think about that as default interest on a credit card is 30%. It's much better to actually allow that. It may be better. So that's something that you might need to take into account when you're just discussing. And please give me a call if you need to sort of talk that through, because I don't think it's your role to say, yes, wait for it. Carolyn, come on. Yes. Yes.
Julia, my understanding is that not all creditors or plaintiffs will ask for interest on the debt.
That's right. But the court file actually begins to add interest automatically once judgment is entered. So there's a period of time between judgment being entered and the first enforcement process, for example. The debt increases. It could also be situations where it's not necessarily, for example, a regulated, so a lender, a holder of an Australian credit licence. It could be another creditor that we're talking about who will insist on that interest. And we've had situations where a client has been sued. 6 years later, the creditor decides that they're going to take legal action. They're going to enforce the debt, and suddenly the debt's doubled because of interest. Now they were private. That was a private arrangement, but at the end of the day, you can see the detriment. Okay, now we're going to talk about one of my favourite topics. Well, it's not really. Insurers. And no doubt a lot of you have had clients who've come to you, and we'll see some of the documents we're going to talk about a bit later, come to you with a motor vehicle accident. They are uninsured. They don't have the third-party insurance that we say to people you really need to get. And of course, a motor vehicle accident is the most common. Can you think of another scenario whereby there's been a motor vehicle accident, but it's not an insurer that's chasing them? Sorry? So that's personal injury, and we talk about that at the bottom. Yep.
When they hit a Stobie pole.
Stobie pole. So are you wondering why the state government or SA Power Networks is suing your client for $6,000, $7,000, $8,000, $10,000? It's because they've banged into a Stobie pole. And they're self-insured, so they've got no insurance. There's no insurer available to pay out, so they've got to get the money somehow. And of course, your client, who's on a Centrelink income, doesn't have a lot of money to spare. It's a good idea. Let's sue them for $10,000. That makes a lot of sense to me. Not. All right, so one of the big questions is that question of liability. Who's at fault? I had helped someone in the debt court the other day. He was a student. He mind you, he didn't handle it very well himself, so there was a little bit of fault. But he said to me, hang on a minute, I was rear-ended. I was stationary at the lights and I was rear-ended, and I'm being sued for this for $6,500 as a student. Mind you, he hadn't handled the whole thing very well because the judgment was 6 months old, but at the end of the day, it's just not clear cut that it's completely the other driver's fault or his fault. It's not really something that you should try and work out yourself, although that's an obvious example. Now he says he was stationary at the lights, but who's to know that he didn't actually slam on his brakes and somebody went straight up the back of him? So working out liability, working out who's who, is very much a matter for some legal advice, some legal help, because there may be grounds for filing a defence and getting the whole process challenging that debt. Remember, what's happening is the insurer is chasing the uninsured, your client. So the insurer's already paid up to the third party, already paid up to the insured person. They're now trying to get some more money to pay for the repairs. So has anyone dipped into the insurance code of practice? No, it's riveting stuff. Oh, you have. Diane has. Riveting stuff. But there is all insurers must comply with the insurance code of practice, and we can send around a link to it if you'd like to. But there is also obviously the requirement that they comply with the debt collection guidelines, and there's a lot of really, really helpful things within the debt collection guidelines that they need to, and treating a client fairly is number one. And if your client's hasn't got two bob to rub together, then why? So many people turn up in court. I'm on a Centrelink income. I haven't been working for the last 6 months. I can't afford to pay anything. The hint becomes to the registrar and to the creditor's agent, well, hang on a minute, this is a dry argument here. You can't get blood out of a stone. So it's just that question of liability, and we'll look at some of, in the letters, in the examples that I'll give you, we've got some beautiful statements by recoveries agents that make you go, hang on a minute, that's not right. In fact, that almost is misleading and deceptive conduct. Another story. Who's come across a claim by the Motor Accident Commission against a client? Anyone seen one of those lovely long letters from a lawyer that says you're responsible, pay up $600,000? No? Not seen that? I've seen a couple of them. Basically, a personal injuries claim. So we all know about the CTP scheme. We all know that we've got to pay our rego and it gives us a premium for CTP. If you're driving whilst drunk, or there are certain other limited circumstances, the policy, your compulsory third-party policy, doesn't respond. So it means that you're going to be effectively uninsured, even though you might have paid your CTP. And it's usually when the driver is intoxicated, or there's some other reason, they're driving like an idiot, it's another reason, or they didn't pay. Motor Accident Commission has already paid out the injured other person. So they've already reached an agreement either by a court decision or they've fixed an amount. So it's a liquidated sum. They then come after, usually your client, for that amount. And it'll be a long letter that explains the circumstances, says you're not insured, therefore please pay us $600,000. How would you like to pay? I've seen circumstances where lawyers have written back letters that say your client has agreed to pay $50 a month for the next X number of payments, 1,900, something ridiculous, and then a lump sum payment at the end of whatever the balance is. we wrote back to them and said, well, hang on a minute, by the time she makes that last payment, she's going to be 119 years old. I don't think so. So just be aware of those sorts of situations, and if you're not sure and your client's thinking about bankruptcy, they are actually covered by bankruptcy. Give us a call, scan a copy of the letter. The client may have assets, and we've had that situation where the client's had assets. What they're basically trying to do, they're obliged to under the Motor Vehicles Act to recover that debt. It may not go anywhere, they may just get a judgment and that's it. But it's very frightening for someone to open a letter and say, please pay $600,000, how would you like to pay? If a person owes council rates or water rates, they own property, they have a house. The council can't write off the rates. SA Water can't write off that debt. It has to be paid. Clearly, sometimes what actually happens is that the person will be juggling mortgage payments as well. So for those of you who perhaps are less experienced, the next question you ask when you see a claim from SA Water or from the council, how's your mortgage going? How are you paying? Because more than likely they're going to be struggling with that as well. The property can be sold. There is a procedure to go through, and in fact, Dara and Belinda have come across the procedure, and it's pretty astounding. It almost involves just putting up a sign out the front for property for sale being sold by the council. The rates have to be outstanding for a certain period of time before that can happen. I think is it 3 or 5? I think it's 3. I think it's 3. We'll double check that for you. So they put up a sign. Suddenly, that's how you know the council's selling your property, other than the bits of paper that you've been ignoring and putting in the rubbish bin or tucking down the back. Sorry? Not opening. So the debt can't be written off. So what basically happens is, even with a mortgagee sale, with any type of sale, at settlement there is an adjustment. So in effect, SA Water and the council get paid first. You can't, and then the mortgage gets paid, and then anyone that's left over at the end of the line, they all get paid out. Carolyn, you can talk to me about utility bills. That's all right.
I think I was making a distinction between a debt related to a utility bill that was an old debt, as in didn't relate to current usage, as distinct from arrears on a current bill. Obviously, if it's arrears on a current bill, that's a priority. You're going to be having communications from the energy retailer, and the risk is going to be disconnection if the client doesn't pay. So if a debt's got to court, if it's a court debt, it's coming up as a claim, then it's not a priority any longer, because that's going to be an old debt. And I think we do see quite a number of clients with old debts where they might have changed energy providers, for instance, and the old energy provider has sent the debt off to a debt collection agency. I just wanted to make that distinction between the two, because then that old debt that ends up in court is not a priority anymore, is it? It's not a priority in terms of their living expenses and current usage of energy and so on.
Thank you. I did go to a session that was run by one of the large, I think it was Origin, who said that they're very unlikely to take legal action, but it's still their right. So it's still a creditor's right to take legal action. It's more that we understand what the process, and we understand that it may not happen. So they usually write them off or try and negotiate a payment arrangement. But of course, with Bear in mind also that, of course, there is the option for that creditor to also to report your client to a credit reporting agency as well. Add a little default listing to their file. All right. So school fees. On the other hand, the Department of Education is very keen to recover school fees, and they will sue for very small amounts of money, which may cause a lot of angst to clients, may cause a lot of angst for the agent, but at the end of the day, it's their entitlement to sue, and that might be for $150, it might be, and the debt shows up as $400, because guess what? You've added filing fee, you've added costs, you've added interest, you've added all the bits and pieces. So, as I've said, encouraging payment plans, and they're usually quite small debts and they can be chipped away at over a period of time. The big ones that we see are often Pulteney and CBC and the big private schools that tend to sue, and it's often as a result of a property settlement. It was him, he signed her up for school, I just took her along, or it was her, she's responsible, not me. And it may well be part of a whole big issue with the property settlement, where there's probably more likely to be more debt than assets to divide up in the property settlement. Normal processes apply with national NCC, I'm talking about the National Credit Code here. If judgment, and this is why it's important to get in touch with the court to find out whether judgment has been entered or not. If you've got any threats of legal action by the creditor, get in touch with the court and just find out whether judgment has been entered yet or not. Because remember, the external dispute resolution schemes don't have jurisdiction if judgment has already been entered. Okay, so be aware of that, and you better get your information first before you pick up the phone to either the creditor or the EDR scheme, because you don't want to find yourself going, oh, I didn't realise that judgment had been entered already. Assignment of debts. So you probably would have seen our friends Lion Finance, Great Western, which I always thought was champagne. I was always amused by that, Great Western. Who's some of the other? ADR? Yeah, haven't seen them for a long time in the list. Oh, okay. They probably don't sue anymore because they know they're not going to get away. Pantera, yeah. Pretty aggressive. So basically what that means is all the bundle, as I said earlier, all the bundle of rights and liabilities all are picked up and given to the and on-sold. And usually on-sold for a fraction, a percentage of the actual debt itself. So that's how they make their money. They'll buy the debt maybe for 10% of the face value of the debt, and then they'll get somebody to pay. They'll get them to pay maybe 20% or 50%, and there you go, bang! They've made their money. So one of the things that we often advise is when we're at the debt court with Ian Small, is if you can negotiate to pay a low lump sum. And I don't know whether any of you have had that experience whereby they've accepted a fraction of the cost because they've made money out of it. All right. Talk about claims themselves. So clearly once a claim is started, legal fees and interest get added to the claim, so it may well increase. Debt collection fees cannot be added. What do you understand by debt collection fees? Yes, yep. What happens if that's actually part of the contract the client entered into? What happens if it's a National Credit Code debt? And there's a list of all the things we can add on. $25 for a default letter. $30 every time your account's overdrawn. Every time we've got to ring you or send you an SMS, there's another $25. What about that sort of thing? Do you think that can be added on to the debt? If it's agreed in advance as part of the contract, yes. But if it's something that is whacked on the end, well, sorry, but you've not paid, so we're going to put on $250 for debt collection fees, then there's a chance to question that. And the rules are very specific that a debt collection fee cannot be added on, but it's only if it's not agreed in advance. So, for example, you go into a dentist, and I don't know any dentist. I've heard of dentists. Dentists actually come up in the debt court list quite a bit, and I don't know of any dentists that actually offer credit. Can I pay this off over a period of time? You know, no, yep. Oh, different situations. So not a debt. I've heard of vets offering a payment plan, and actually a third party. Sorry, through GE. Yes, so a third party credit provider. So this is actually just a private arrangement between you and. Don't they allow you to pay off? Yeah. So you've got that, and you're paying away, and suddenly you've stopped paying. Has anyone had the experience of they add on something extra for debt collection? Sometimes they do it. I've seen it happen. But did you agree to it as part of the arrangement to start with? And that's the thing, is that you as a client or your client, did they agree for that $250 to be added on as a debt collection fee that would then become part of the whole claim that the client sued for, that becomes part of the claim? This is something that's been picked up by Consumer Action Law Centre a while ago. The court doesn't check to see whether the amount is correct. That's not their role. Their role is just to make sure that the fees are right, that they haven't added too much for costs within the. We'll come up to a claim in a second. But the amount of the debt is not checked by the registry. So the registry could be the creditor could be suing for any amount, and it's never scrutinised, because the registry doesn't give legal advice. That amount is something that your client can question. Service is generally done by the court by post, so you pop it in the post, and now with our 4-day posting cycle, the rules now talk about deemed to be served, and it has actually changed recently, but the period of time has been extended because of that 4-day posting new postal rule. We usually say to people, wait 5-7 days for it to be posted, just to allow for the exigency, things to go wrong. I often hear people say in the debt court, I never received the claim. Now, I had my eyes closed, I didn't receive the claim. I didn't get the mail from my post box, I never received the claim. There's also life has gotten on top of me and I didn't receive the claim because I didn't look at it. I didn't want to look at it because I knew that I was being chased.
Can I just ask, I had a very difficult one because it couldn't be served in person because they couldn't find a home address.
Right.
You only had a post office.
Right. Now, with a claim, they don't need to be served personally. It's the investigation summons that needs to be handed to the person. So it can be just a postal address, so like a PO box. But as you said, it's often if a PO box. Well, how are you going to find the person? So that does actually make it quite difficult. They can make application for deemed service, but it's very, very uncommon to do. Okay, so this is copied out from that one in the booklet. Thank you. And that's actually not very big either. And it actually does talk, here we go, it talks about Eleanor, her case study here. Now, I've fudged it a bit. I did something. No, I didn't. Not with this one. But really all of that does is show you the amount claimed, the filing fee, which is now 138, was 123 at the time the booklet was produced. And this, I've added in solicitors' fees. Lawyers can actually, even though we say lawyers don't get involved in minor civil action, they can actually help with the drafting of a claim, which is, these are the particulars of the claim just here. And I'd have a look at that because you might find some things in there that are a bit that you don't understand. So a lawyer can actually prepare that and they legitimately can add in. That's not a debt collection fee, that's a legal fee. So, and there's a scale, and the scale keeps a real cap on those fees. The rest of it seems to be fairly straightforward. Here you can see method of service by a registrar, and that actually means that the method of service is by post. So they'll just stick it in the post box and hope that it hits the mark. One of the important things about service here is when did I get it? When did I receive the claim? Now, remember I talked about the deemed period of time. So it's posted on the 1st, and I think it's now 5 days. I could be completely wrong. I need to go back and double check the rules again. But it's considered to be served by, let's say it's considered to be served by the 7th of February, so posted on the 1st, served on the 7th. So the person has 21 days from the date of service, not the date of filing, not the date they took it into the court, not the date the court posted it, but the date that they received it. So if your client is saying all of these things, we need to find out when they actually received the claim. So I shouldn't have to pay for this. He crashed into me. Minor bingle, I paid it. All of the things that you've probably heard before. And we talk about different defences when, it is in here somewhere. There might be defence. On section 1, on page 6, there's actually some options, things that clients might say, might give you a basis to dispute the debt. But being alert to those statements that your client makes, should you be doing? Do you hear any of those words? Get legal advice. Filing a defence sets in train a whole different process that really gets you out of the realms of a financial counsellor, absolutely out of the realms of the financial counsellor. But it's about being alert to those things that the client actually does say to you. In fact, Carolyn's comment is ask the client if they believe they owe the debt. They're the words that you would use? Yeah. Or are you liable, or are you responsible for this debt? So getting legal advice pretty much as soon as possible. I was going to say about service of the claim, and you're not sure when it was served. Remember to call the magistrate's court. We need to obviously produce a third-party authority, but give them a call, 8204 2444, because they should be able to tell you. It's on the court outcome, the record of outcome, the court record. It will say when the claim was served, when it's deemed to be served. Getting legal advice is pretty important. There is some issues that come up with family law that I think financial counsellors should be aware of as well, not to get into that whole there might be rights that your client has that you're not aware of under a family law split, or that just might need some basic legal advice before you continue to help them, okay? So be aware of that. And also business failure debts. That seems to be happening more and more nowadays. And as I mentioned, the whole new process starts if a defence is filed. We did actually just quickly talk about the interest running pre-judgment. And I think I've covered off those little aspects of it. Doing nothing, obviously, default judgment, now that shows up on the credit record as a default. That's a separate thing to report by the creditors of the credit reporting agency. That's separate. Defaults show up as default judgments which are sold to the credit reporting agencies by the court. So it's a list that they get every so often. Obviously there's loss of control by the client. Judgment can also arise as a result of a trial. So if your client's filed a defence, gone to trial and said to the magistrate, he banged into me, and the other person said, no, he banged into me, and the magistrate believes the plaintiff, then suddenly there's a judgment as a result of a trial, defended and argued before a magistrate. All right, post-judgment option. Judgment basically means it's a decision of the court that the money is owed. And usually, in fact, there's a percentage, what's the percentage? About 80% of claims are not defended in the magistrate's court. They go through to the keeper, default judgment is entered. The creditor may decide to enforce it, or they may just say, look, we've got the default judgment, that's enough for us. Once now the judgment is entered, we now get to the point of enforcing the debt. And of course, that's often when we get the phone call. I've got something from the court, I don't know what it is. It is possible to set aside judgment. So a client may come to you with documents and you can work out that suddenly judgment has been entered, but there's some very limited circumstances, and one of them is, why on earth didn't you file your defence before? And the other one is your defence a good one? If you don't have a good defence, then you're not going to get past go. But if you can't say, if you also can't give a good reason why you didn't file your defence in time, the magistrate may also say no. Okay, so who's been to the debt court? Who's sat in the back of the debt court? Anyone? Very interesting process. And if you can get some time, it's worthwhile going in and seeing exactly what happens. Get in touch with Ian Small if you'd like to, if you're really interested in going. So basically, it's a summons. Now, summons basically means you have to come to court, and the importance of the summons is actually is receiving the summons personally. So it has to be served personally. And a lot of times, if the summons can't get served, it lapses and they've got to try again, and that in itself can cause problems. So the creditor's agent is the one that sits there and asks the questions. And look, to her credit, there's one who does it, one person that does it seems to have a monopoly in the market. maybe needs some competition. The presiding officer is a registrar. It is sworn evidence that person gives about their financial position. And I have heard that they will accept an INE as long as an INE prepared by a financial counsellor. A lot of people are clueless. They get there and they scribble things down. They've got no idea what they're talking about. Electricity, $300 a week for food. You will get asked about that. All right, including spouse's income. They ask about the spouse's income because they need. If you're living together, your living expenses are going to be different. And the enforceable payment order is enforceable, and is enforceable from a couple of points of view. The first one is that if payments are missed, they can get brought back to court to answer questions as to why those payments were missed. If they can't give a good reason, then they can face a prison term of up to 40 days, and that doesn't scrub out the debt. So it's pretty important that the person doesn't just simply say, well, I can't be bothered, I forgot, I ran out of money, whatever. But the Enforcement of Judgments Act actually is quite specific. Cannot impose unreasonable obligations on the debtor. What's unreasonable? Reasonable is actually quite an open word, or unreasonable is quite an open word. And I think that's got a lot more force, even though we do rely on the provision of the Social Security Act. I think that's got a bit more force because it's part of legislation, whereas the Social Security Act argument with the Centrelink income is only really applicable to Centrelink recipients, whereas you think about a debtor who's actually underemployed, or works part-time, works casually, has a large family, has other obligations. So unreasonable obligations on the debtor is pretty important. What rights do they have? Does the client have? Asking for an adjournment to get legal help, financial counselling help. They're very obliging. They will do that for you. Stating that you're unable to pay is another thing. A lot of people say, oh, $20 a month, you've got no money. They can see that from your income and expenses statement. What orders can a registrar make? That the instalments begin on a certain date. But, you know, I look at that and I see someone's got a $10,000 debt and they're paying it off at $20 a month. How long is that going to take to pay off? I don't know how many debts are sitting there still being paid off at $20 a month from 10 years ago. Who knows? I don't know whether they exist. But there's a whole range of other orders. The no order is a good one. And the no order can actually be for a period of time, say 6 months. And usually at that point the creditor says, well, the client's position is not going to improve, we're not going to chase it. So if an order has been made, the client and the client's circumstances change. For example, they're working and then they lose their job. They can actually go back to the court, and they simply have to go back to the registry and ask for a variation. But this is the critical one. If an order is made and they have no reasonable excuse for not making their payments, they can face an imprisonment order. But I think that's very unusual. Has anyone had that situation happen? No. I've been in court where they've said, right, you're going to go before a magistrate, and I don't know what happened. I don't know what happened. But it's going before a magistrate and telling the magistrate why, and I doubt very much whether or not. I mean, it has happened. Other enforcement action, if your client has assets, there can be a warrant of sale or a charging order. Warrants of sale can be done over house or land, shares, boat or caravan. The warrant can be stayed in limited circumstances. Again, legal advice is essential. Bankruptcy, as a result, if the debt is over $5,000, the creditor's petition can kick in. Clearly, if there's a bankruptcy notice, get some legal advice fast. We've got situations where people ring us up and say, whoa, my wife has been made bankrupt. She's a joint holder of our property, and the debt was originally $10,000, and now the trustee in bankruptcy said, oh, it's up to $50,000 or $60,000. Their fees are astronomical, just mad, absolutely mad.